Hello, this is James Robert Deal, coming to you from Linwood, Washington. Today is September the 10th, 2018. The topic for discussion is mortgage modification, also known as foreclosure defense. Now, I am primarily a real estate broker at this point in my career. However, I still will do a mortgage modification on a selected basis. First of all, I talk to people on the phone for no charge to figure out if it's possible that I can help them. If I can help them, then we'll arrange an initial consultation, either face-to-face or over the telephone. We can even do screen share because I work for buyers, sellers, for owners throughout the state of Washington. So what are the essential pre-requirements for obtaining a mortgage modification? Your chances of getting a modification are much better if you have little equity in your property or if your loan is underwater. If you have like 10% equity in your property, you still have a reasonable chance of getting a modification, because borrowers generally will get modifications only when it also benefits the bank. Everything in the modification program, Obama, the Making Home Affordable, and is from the bank's point of view. If there's plenty of equity in your property, you've got a small mortgage, you're a little old lady, there's no chance you're gonna die at some point. The property's gonna be sold or refinanced. They don't care. If you're not paying, then they have the right to foreclose, and the little old lady has little income, so she can't qualify for modification. So she may be forced to sell, or she might go into a reverse mortgage. I like reverse mortgages, particularly if you're going to keep them for a while. Also, it helps if, and is necessary, that you have had a hardship. Now, everybody's had hardships, so usually that's not a requirement. We need to look back to a date where you either got behind on your payments or had trouble making your payments. It can be in the past. So the storyline in your hardship letter should be that you had a hardship in the past, but you have recovered. Your income has stabilized. You're now able to make regular payments. So we try to pinpoint a date when you had your hardship and then write the hardship letter and pinpoint that date. I think the hardship letter is a formality. But if you haven't ever had a hardship, maybe they'll decline you. So you also have to have the ability to make the mortgage payments for them to agree to give you a modification. And generally the ratio is 31% of your gross income can be spent on your loan. So you look at what your old mortgage payment was, and you multiply that, you divide that by 0.31 to get the income that you would need to qualify again for a payment of approximately the same amount. And you can test this by taking that gross income, or the gross income you have, and multiplying it by 0.31. And that's the mortgage payment you can afford. Now, if your current mortgage payment is higher than that, then it's possible that the lender will lower your interest rate for a few years, up to 5 years, 6 years sometimes, so that you can get a running start. And generally, if it's a Making Home Affordable type of loan, which I think Fannie and Freddie have continued doing those, but the regular banks aren't doing those anymore. You start at 2, and after 5 years you step up to 3, and then to whatever the federal rate was at the time your modification was granted. So a modification being granted today would perhaps start at 2, step up to 3 and 4, and then to 4.5, which is approximately the federal rate today. Or a lender's not obligated, as best I understand it, assuming they're not Fannie and Freddie, they're not under any program that would require them to start you off at the 2%. They might start you off at the 4.5%, which might be lower than what you had before. And you might get that for 30 years or 40 years. And all that helps to lower your payment. So you can end up with a lower payment. Now, principal reductions are not common, but they sometimes occur. What is more likely to occur is a deferral of maybe $100,000 worth of your loan so that it doesn't bear interest and you don't have to make any payments on it. And it all comes due when at the end of your amortization of the part that is amortizing. Now, there's also a possibility that if you have a second mortgage, you can get that mortgage forgiven, particularly if that second mortgage is being carried by the same servicer. But that's certainly not a guarantee. I have gotten second mortgages dropped for people by filling out all the necessary forms and sending them to the reconveyance department. Now, I want to make it clear that mortgage modification is the practice of law. And if you're getting calls from people who are not attorneys, or if they say, well, we have an attorney that checks everything, then you would want to say, what's his name? What's her name? And can I speak with her briefly? And if that's not possible, then what they're doing is renting a lawyer's name. Also, in the state of Washington, the law says that mortgage modifications here can be handled only by lawyers or loan officers who are actively licensed in the state of Washington. So if you get a call from out of state, say, are you licensed in Washington? Well, no, we're not. So they're really not qualified to do this work. But a lot of companies disregard this, and you'll see advertisements on TV late at night advertising mortgage helpline, and they'll say misrepresentations such as that we know things that the bank doesn't want you to know, which there's some truth to that. They don't tell you what you're doing wrong, and that's why you need to engage me. And one of the reasons why I'm still able to do modifications, even though I'm primarily being a broker, is that I have a secretary, wife, co-broker, she's also a broker, and she's done a lot of legal studies, who can help me with the day-to-day work that's involved in mortgage modification. There's a lot of calling, obtaining documents, following up on things, making sure that everything happens. Now, there is the possibility that you might go into a Chapter 13 bankruptcy. And might be a necessity if there's a foreclosure date and you can't get it extended. Now, one of the rules that applies to most lenders other than Fannie and Freddie is that there are no rules about modification. There's nothing they have to give you. However, the only rule that applies is that if you submit your application 37 days or more before your foreclosure date, they must look at it and apply whatever mortgage modification options they have available. And they'll probably have options available if they are options that increase the value of the mortgage. So if a mortgage gets stabilized and a borrower starts paying again, even if the interest rate is reduced, Uh, Especially if the property is underwater, it is to the benefit of the mortgage company to go forward with modification because they can turn around and sell that loan and get all their money. So during the Making Home Affordable period, which is also called HAMP, Home Affordable Modification Program, or Making Home Affordable. One or the other of them was more of a Fannie Freddie program, and the other one was for non-Fannie Freddie lenders. And it's my understanding that the 2% rate is more likely to be available if it's a Fannie Freddie modification. Fee-wise, I can work two ways. I can work by the hour, but I prefer to quote a flat fee, and usually it's $3,500. And then I also ask for a completion bonus when it's done, and the completion bonus is often $2,500. Now that adds up to $6,000, which is the type of fee I used to charge when I was a loan officer, putting together challenging loans. And I find that if I do it on an hourly basis, that it's more than that. But it's to my benefit to have a flat fee with payment of a little more than half to start, and then a bonus when it's done, because we sort of split the risk. I want to be paid at least half of it, and I'll let you pay that in a few monthly payments. I'll also take credit cards. And so I know that you're committed to me, and you know I'm committed to you. And you know that I'm going to work hard because I've got a completion bonus coming to me when it's done. So, yes, sometimes we have to put the borrower into Chapter 13 if they've waited too long. And I really do think that they will take you more seriously in your modification if you are in Chapter 13. Because you're going to get rid of a lot of extraneous debts. And also a Chapter 7 bankruptcy will stop a foreclosure, although it will only stop it for the period of the Chapter 7. And Chapter 7s are usually over and done in about 4 or 5 months. Now, if a lender really wants to proceed with the foreclosure, even though you're in Chapter 7, the lender can make a motion for relief from stay. Because when you go into bankruptcy, there's an automatic stay against foreclosures, repossessions, and evictions. If a creditor wants to proceed, they need to make a motion. So if you go into a Chapter 13, the idea is that you're going to make monthly payments. And if you're also working on a modification while you're in Chapter 13, you will want to start making payments in the amount that you used to pay before you defaulted. In other words, you're not required to start making catch-up payments. If you just give up on modification and say, I'm not going to go for that, I just want to pay my arrears over the duration of the bankruptcy, then if you're in a 36-month plan, you pay your arrearage over 36 months plus your regular payment, plus an allocation to go for your attorney, plus another 4 or 5% to go to the court. You can proceed with modification while in Chapter 13. You start making your old payment, and typically the court will give you 6 months to allow me to negotiate something with the lender. So you have to send them the right forms. You have to send them your tax returns for the last 2 years, your pay stubs for the last 30 days or more. If you're self-employed, you have to do a profit and loss statement. You have to show a statement of all your home expenses as apart from your business expenses. If you have somebody living in your home who either pays rent or who shares with the overhead, pays the utilities, contributes $500 a month towards food and utilities, you can add that to your gross income to qualify under the 31% formula. So if a property is owned just in the name of the husband, then you can also use the wife's income. She doesn't have to go on to title in order to sign up and say, yes, I'm supporting this mortgage. And if a wife or your children or a renter who rents with you, a relative co-signs that, who signs and commits monthly income, does not thereby become liable on the loan if later there's a default and a foreclosure. So which encourages those who live with you to sign on to help you. Now, I'll say a word or two about mortgage mediation. Mortgage mediation is another way to avoid foreclosure, and it's a way to gain more time. So, however, it is not in and of itself a way to get a modification. At the same time as you file for mediation through the Secretary of State in Washington, and every state has its own mediation type program, you must request mediation within 20 days after you get the notice of trustee sale. So the steps are, first, a letter that says, we're sending you notice of your foreclosure options. You're in arrears. And then they send you a notice of default and they tape it to the door. And then they'll follow up with the notice of trustee sale, which they have to tape to the door or deliver to you personally. And all that process takes probably 6 to 7 months. So as soon as you get the notice of default, then you can file for mediation. Or you can wait until 20 days after you receive the notice of trustee sale. So, if you're going for mediation, you must fill out your modification papers. So, meaning that it's an additional process, and usually it's $1,000 to get somebody into mediation. And only an attorney or a licensed loan officer can file a mediation for a debtor. You can't do it for yourself. And I have to make certain certifications that this is owner-occupied. Mediation is only available for owner-occupied, although lender and borrower can stipulate that although mediation is not required under the law, that we both agree that we will mediate. So I'm rather cynical about mediation because unless you can convince the lender to give you the modification, you will not win in the mediation process. So if they're saying that, you have too much equity in the property, so therefore we do not want to modify, because you could sell the property and pay us off, or we could foreclose and get all of our money, and maybe there'd be a little bit left over for you. So, or you don't have enough income for modification, so why should we give you a modification? Just sell your property, or do a short sale. We'll cooperate with a short sale. Or quit claim deed the property back to us, and we'll give you a release of liability. sort of off the subject, but relevant to inform you that if you default and get foreclosed or do a deed in lieu of foreclosure, the lender will issue a 1099-C, which is a report to the IRS that you have received forgiveness of debt, and that might be reportable as income. You can avoid having to report it as income if your debts exceed your net worth, or if you have filed bankruptcy. Over here you see my webpage for mortgagemodificationattorney.com. If you know somebody who's in trouble of losing their property, send them here. Tell them to call James at 425-774-6611. I like this website. It leads you to my other website, Washington Attorney Broker, where you can read more about my working with buyers, sellers, and brokers. And I continue to upgrade it. I continue to get referrals off of this website. So if you decide that you want to do mediation, here's where my train of thought is back. The only advantage, and it is a real advantage with mediation, is that you can use it to just keep extending and extending and extending, and all the while you're extending, you don't have to make monthly payments. And my clients like that because they have money available to deal with their other problems and pay me. So don't hire an out-of-state person. Don't hire a loan officer to do your modification, even though they're licensed to do it. It is the practice of law. There's too many legal issues. Now on my website, I've got a list of the dozens of loan modifications that I've obtained over time. So there's also the option to go into Chapter 11. This applies to non-owner occupied properties. Now, Chapter 11 is very expensive, but it is a fallback that can be considered, because if you can successfully convert your home into a rental, then you could file for Chapter 11. And the advantage of Chapter 11 is that the court can actually force the lender to give you a modification, but you still have to fill out my modification papers and demonstrate to the court that you can make your payments, that you have enough income at a reasonable ratio to cover your mortgage payments. And the other advantage of Chapter 11 is that if your property is underwater, Chapter 11 court has the power to give your lender a haircut, to cram down the balance owing on your mortgage to what the property's worth. Now, the disadvantages of 11. If you're living in the house and your bankruptcy court may have changed their position on allowing you to just move out and lease the property and therefore call it a rental. So this is still a developing aspect. And then Chapter 11 is going to cost you about $15,000 up front. So the first step is to try to get your modification just by applying and using the services of a lawyer who's done a lot of these. I can't think of anything else to say about that subject, so I'm going to simply close with a commercial message, and that is that I'm a real estate broker, real estate attorney throughout the state of Washington. I help buyers, sellers, and brokers. I take listings, especially in the Linwood, Seattle, Everett area. In other areas, I co-list with other brokers. You need somebody on the ground there. But if the property is one that is a little complicated in some way, an example might be a property that doesn't have an operating septic, so there's going to have to be seller financing. It is land. It's a commercial deal. It's a business opportunity. It involves a seller financing, a wraparound, an assumption. It involves a seller or a buyer who represents a trust. In other words, they want an attorney involved to make sure they come out of this clean and they have not done a disservice to the beneficiaries of their trust. So my typical fee for being a co-broker with somebody is at least $2,000 payable at closing. Now, if it's all negotiable, and it depends on how much involvement is necessary. If you're a real estate broker and you have an opportunity to take a transaction to represent a buyer or a seller, and you feel like it's above your pay grade, then give James a call at 425-774-6611 and say, James, would you like to co-broker with me on this deal? It gives you credibility. It helps the broker to get the listing. It helps to deliver a better service to the client, and it takes a load of worry off the broker and the customer, because I'm covered with malpractice both as a real estate broker and as a real estate attorney. And I've been doing this for over 30 years. So I'm going to say goodbye, and I'm going to follow up with some music that I play here. It's the practice of law and real estate that pays the bills, but it's the music that gives me some degree of satisfaction. You might also check out my book, which is all about vegetarian eating, and the clever title of the book is What to Serve a Goddess When She Comes for Dinner. And it's about how men and boys can cook for themselves and cook for the girlfriends and wives in their lives. And it's based on the theory that compatibility in the kitchen may mean that there's compatibility in other rooms within the home. And boys, girls, children should be able to cook for themselves. And it takes some instruction to make vegetables taste good. So mainly, my book explains that, and the history of vegetarianism, the various religious groups that have believed that's important, religious leaders such as Jesus who were vegetarians, Pythagoras, Leonardo da Vinci. So that's to be found at whattoserveagoddess.com. Then there's also WashingtonAttorneyBroker.com and FluorideClassAction.com, which is my website dealing with the scandal of fluoridation, which is adding toxic waste to your drinking water. Every liter of Seattle, Tacoma drinking water contains 3 trillion atoms of lead, and it wouldn't be there except for the fact that it comes along as a bonus with the fluoridation materials. It's just a profitable fraud. And if you go to jamesrobertdeal.org, you can read about more of the profitable frauds, such as smart meters and 5G. We're all going to be fried by that high-energy technology. September the 10th, 2018, my little brother's birthday. Happy birthday, Chad. And happy birthday to the 1/365th percentage of the portion of the population that has a birthday today. And good night.